I have been supplied all the documents and I have not specified which documents were not supplied. Whereas, my lord, in the writ petition itself, I had pointed out.
Now, have you preferred appeal or not?
Yes, not.
No.
Even though, my lord, even though 4 days after,
your
he
lordship
wrote to
may
us
just
saying he's going
hear-
on appellate remedy.
This will shock your lordship's
I'll show the
conscience
mail.
as to what has happened.
I will show only one.
Your lordship will
document.
just hear me for 2 minutes. Now, my lord, in this proceeding, the insolvency proceedings, one NCLAT member passes an order saying, I have been approached by the other side to pass an order in their favor, and therefore I am recusing in this matter. Thereafter, my lord, we file a writ petition in this court saying that please investigate who has approached them and take action against this this party. On that, my lord, if your lordship just sees that order of this court, I'm saying that this is all connected to that. And recently,
Court passes order on 6th October.
and my lord, recently, just one second.
Look,
Recently,
that first.
recently,
He came to us and saying he's filing appeal.
just one second.
Sent a mail to us.
What is your liability? What is the liability?
70 crores. 5 years. 5 years. 70
And
crores.
recently, my lord,
Fake invoices.
this gentleman, my lord, he claims to be on caveat. He is not a party to the GST proceeding.
I'm the Telangana government representative.
Achha, you are the Telangana
Ah,
government.
you are
All right,
showing
very,
that
very,
government
very, very good.
representative.
Now, my
I'm
lord,
the
this
Telangana
Telangana government, this GST authorities under the Telangana government has been accused in a writ petition before this court, on which notice has been issued recently by this court, to be in complete collusion with this company which has gone into insolvency because of they raid both the operational creditors, that means me and the other company, on the same dates, on the 24th of December 2023. Soon after, my lord, the NCLT upholds insolvency and says that, look, my GST bills, etc., are all attached, and therefore it is clear that they have not paid me. On that basis, insolvency is admitted. After that, my lord, the GST authorities raid me as well as the other operational creditor, and they start passing these orders. First order that they pass against me is set aside by the High Court on the ground that it is not signed. Pass another order. Second order is set aside on the ground that they have not supplied the documents. They still pass another order despite the fact that the Act itself says that they cannot, from the date of the issue of the show cause notice, they cannot pass a final order in less than 6 months. That's the Act, 74(2) of the GST Act. And yet, my lord, they issue notice to me on the 29th of April and pass the final order on the 2nd of July. The case, my lord, which is so serious.
Can you show the order in original?
Yes.
And the interrelationship between your company
Yes.
and this KLSR? In what
Yes.
context the merits of the claim of tax? are?
Yes. Your lordship must see the order of NCLT. NCLT
passed by GST has
in
nothing
the
to do
additional
with that.
documents.
Nothing to do with that.
Additional
And not-
document. Just hold on.
1 minute.
Hold
I'll
on.
show you one document, my lord. 6th October, High Court passes the order. 10th October, he sends a mail. 8:41. He has kept it.
We'll just see both.
Yes, my lord. The order is
And the order in original.
additional documents, volume 1, page 204. 204. Para Roman 23.
Annexure P.
NCLT order.
Annexure.
This is annexure. It's page 204. Annexure concept. I'll just tell your lordship what is the annexure. Page 204 of
P38.
P38.
Head of P38.
14th of July.
38. And then, my lord, at page 204, that is PDF page 212 of this additional documents. Roman 23. Indisputably, in respect of the invoices under which payment has been claimed by the petitioner operational creditor, the receipt of which has been acknowledged by the respondent, GST has been paid by the petitioner on all these invoices. That apart, part payment in respect of some of these invoices has even been made by the respondent through pre-arrangement of LCs, post claim of audit and records of the respondent. The petitioner also enclosed e-bills, etc. And then the next paragraph, it is strange that when it is the case of the petitioner that the supplies under the invoices were genuinely made after paying GST accompanied by e-way bills and delivery challans, the least that is expected from the respondent which is disputing these invoices is to exercise its statutory authority of raising a dispute before the authorities under GST. Under the GST Act, stating that the invoices were fake by submitting GST R3 so that the genuineness or otherwise of the subject invoices would have been decided. So therefore, my lord, on this basis, my lord, the insolvency is admitted.
Correct.
Against which, my lord, they go to NCLAT. In NCLAT, my lord, they approach one of the members of NCLAT, this company.
What
And
is
that-
showing my,
that-
I really regret this. I don't know why it is
Actually, there is a
stand corrected, Mr. Bukit.
there is a writ petition which has been filed recently on which notice has been issued by this court, where the precise allegation is that the state GST authorities are in collusion with this company, are in collusion, and on that notice has been issued, asking for a CBI investigation, etc. into this matter. This is the petition. This is the order. If your lordship may just see this, just been issued, and this court just pass this. This is the petition on which 2 copies. On which see the last page, the prayers, and see, my lord, the order.
Intervention. We are the petitioner, Article 32 petitioners in that.
In that petition, because there were 2 operational creditors on which basis, my lord?
Where is the praise?
See prayer C. Last page, prayer C. Last page is the prayer.
What are the grounds on allegation that GST authorities have
Correct.
Yes, state. So that is clearly in the petition, my lord.
101.
Para 101. 101 onwards. 101, 102.
Says that
Totally in collusion with this company. Totally. They seize our documents, thousands of pages of our GST invoices, etc. Do not give us copies, though the Act requires them to give us copies immediately if they seize anything. And then they don't give us copies for years altogether. We go on asking them. Second. Just see, my lord, they admit just before the order is passed that they have not supplied us the documents.
You can see everything behind my back.
And a 200-page order is passed on the day of the oral hearing. 200-page order, and that order is given to this other company to be produced the next day in their written submissions before NCLAT. Can there be, my lord, grosser evidence of complete collusion between the GST authorities and this company? Everything is being done at the behest of this company.
Can I want to respond.
Yes, yes.
Not all of us represent Telangana government, not any company, as my friend keeps showing the finger. I
The
want to
company
understand-
filed-
1 minute.
Mr. Venkatraman,
Yes.
we propose to say that let this petition be heard along with this,
I have one.
Yes.
which is pending before.
Well, I have one
first-
submission to make. I have only one because now this is a new engineering route. You can now allege anything against anybody behind our back and start.
No,
But
no,
this,
it's not alleging. Notice has been issued. See, the point is this, what they are saying in 4 lines. There is an insolvency proceeding initiated by the operational creditor, which is this company,
AS
Yes,
Metcor.
AS Corp.
And Bengal. And Bengal.
Intervener.
Huh.
Pending admission of the CRP and the process of CRP, his case is the director of the corporate debtor there, using his influence with the government, has initiated proceedings,
Correct.
used the GST, which is part of the state machinery. Now, if it is only allegation, it's a different matter. Yes, ground is raised in ground page para 101. And on that, the Chief Justice's bench has issued notice and the matter is pending. So as the Honorable said, let the matter.
I have some.
And my Lord, the
Sir,
Chief
you-
Justice had also ordered
My friend has
the
been heard for
transfer
15
of the
minutes.
NCLAT
Hear me for 5
proceedings
minutes. I have
to the
something to say.
principal bench
I
to
want
be heard
something
by
to
the
say.
chairman.
Please hear us. Lord, please hear us for 5 minutes because something very important. Lord, this is a third round of writ petition this man is making before the High Court. Third round. And in none of the 3 rounds, he has made any of these case against us. In all the 3 rounds, his case was copies were not furnished. Copies of the invoice. This is a case, blatant case of a fake invoicing. You keep receiving fake invoices without receiving the goods and start taking credit. 5 assessment years have been passed for 70 crores. Please see the last impugned order. Nothing has been said against us. He's saying all this from NCLT, NCLAT, and showing here. Nothing was argued in the High Court.
So it doesn't matter. Let it be argued before the first court. Take down.
We are not saying anything. Mr.
Can
Krishna.
I just say one thing, Malaz?
This petition arises from.
See, well,
Malaz, just one thing. I'm appearing to KP for TLSR because
KLSR is that company which went into insolvency due to
But he will argue for
My
everybody.
operation.
Then when will we get a turn, my lord?
all I'm saying because we got been served a copy of the papers with the principal bench of the NCLA.
We are not entertaining this.
They've preserved the
We are not hearing this matter. This petition arises from the judgment and order passed by a division bench of the High Court for the state of Telangana dated 6/10/2025 in writ petition number 29376 of 2025, by which the writ petition preferred by the petitioner herein seeking to challenge the order in original dated 2/7/2025 passed under section 74 of the Telangana Goods and Services Tax Act 2017, for short the TGST Act, came to be rejected. Full stop. We heard Mr. Prashant Bhushan, the learned senior counsel, appearing for the petitioner, Mr. Venkatraman, the learned ASG, appearing for the state of Telangana, and Mr. the learned counsel, appearing for
they
the
are not parties. This is that company which has gone into liquidation.
appearing for
TLSR in fact
KLS
Here.
K
KLS.
measures KLSR Infratech Limited bracket, not a party before us. Okay, full point. It appears that the principal argument of the petitioner before us, it appears that the principal argument that was canvassed before the High Court by the petitioner before us was with respect to not providing of relevant documents seized during the inspection. Full point. To put it in other words, the petitioner redressed a serious grievance before the High Court that the order in original came to be passed in violation of the principles of natural justice. First up. The High Court, while rejecting the writ petition, observed in paras
Right.
12,
Yes.
observed in paras 15.
Lord, para 7 is important. It catalogs all the dates of hearing.
Take a minute.
How many opportunities?
Paras 15 and 16
many
respectively. Full
But
point.
this is-
The two paragraphs read thus, quoted. Okay? Fine. In such circumstances referred to above,
No, we can explain this ground.
they will have to say that.
Go to this petition at all, my lord. In this case,
Mr. Bhushan, the learned senior counsel appearing for the petitioner, brought to our notice that an offshoot of this litigation is in the form of a writ petition preferred before this court, being writ petition bracket criminal number 19 of 2026, titled Saurabh Agarwal versus Union of India and others. It was brought to our notice that this writ petition is being heard by the Court of Honorable the Chief Justice of India. Full point. The learned counsel also placed before us the memorandum of the writ petition referred to above and invited our attention to the amendments made in paras 101 to 103, respectively. The three paragraphs read thus, quote them from here. Okay? Fine. On the other hand, Mr. Venkatraman, while vehemently opposing this petition, submitted that
3 paragraphs, my lord.
the High Court has, after due consideration of all the relevant aspects of the matter,
And
rightly declined to entertain the writ petition seeking to challenge the legality and validity of the original order in original passed by the authority concerned.
my lord, one more reason, my lord. 2,400 invoices given, and we asked him, what more do you want? He never furnished anything.
We
He never asked for anything.
The learned-
Never asked for anything.
the learned
2,400 copies given.
The learned ASG invited our
And
attention
my lord, last point.
to the observations made by the High Court as contained in para 7 of the impugned judgment of the High Court. Para 7 reads thus. Full point.
And one last point, my lord. The High Court passes this order on 6th October. 10th October, he's writing a mail. Let the order be uploaded. I will go on appeal. I will file a statutory appeal, is what he sent to us.
Okay.
All this is news story.
In the last,
P25 of the writ petition contained all the details. of the topic
847,
was not supplied.
841. Can I read 3 lines?
Mr.
Please let the order be
Venkatraman,
uploaded. I'll go on appeal.
Mr. Venkatraman has many other contentions to canvass to highlight the bona fides of the present petitioner. Full point. Next. We are of the view that let this petition before us be heard along with writ petition bracket criminal number 19 of 2026. Okay? Registry shall place this order before Honorable the Chief Justice of India. Okay? Fine. Okay, brother. No.
I am obliged.
Sure.
He has to fill it.
Lordship, item 14 is Tola, Your Lordship.
Tola.
Your Lordship, item 15